Okay, Mr. Berman, you're up.
Good morning, Your Honors. I represent four petitioners: Madeline Silva, Marie Silva, Mike Quill, and Nada Abdu Quill. This case has been going on since 2012. It alleges a conspiracy to defame the plaintiff. The alleged conspiracy was hatched before June 9th, 2011. And in fact, the end goal of the conspiracy was to cause plaintiff to be arrested. And the first arrest was on June 9th. The second arrest was on July 1st, both in 2011. The undisputed facts is in 2015, while this case was pending, plaintiff filed a federal action that I refer to as the Bondi action in my brief. In that one, she alleged that three of my clients participated in a conspiracy with law enforcement to give them false information to cause a false arrest. Eventually, that lawsuit was thrown out on a 12b6 motion based on the arrest affidavit. Then in January 5th of 2018, again, Marie, Mike, and Nada were added to what I call the Dirks action, which was a case filed in Hillsborough County against some of the narcotics detectives and people involved in the arrest. She added them. All the defendants removed that case to federal court, and Judge Moody again threw it out. On appeal, those judgments, the judgments were affirmed against plaintiff. And plaintiff petitioned U.S. Supreme Court, denied cert. The lower court was given briefs by each petitioner, separate briefs. And there was no real testimony, live testimony offered in this hearing before Judge Polo. Judge Polo issued what I would term a summary denial of the 68.093 motions to cause her to post a bond. So the judge, in our opinion, departed from the essential requirements of law by one, issuing a summary denial. Number two, not concluding as a matter of law that the plaintiff was not reasonably likely to prevail based on two primary arguments that we make in our brief here, both of which were argued in the lower court. First, the statute of limitations as to Madeline Silva. She was a co-conspirator beginning in October of 2010. She posted things online, false reviews, allegedly. So her claim is extinguished by the statute of limitations, and it starts not when the plaintiff finds it, but when the publication occurs, so by the time Madeline was added to this current lawsuit in 2016, the statute had already run. The second thing we argued extensively in the lower court is res judicata. Res judicata requires that the two lawsuits share a common nucleus of operative fact, otherwise known as the same cause of action, which is not the name of the theory, but the series of acts or transactions that gives rise to the cause of action in the complaint or count, each separate count. So we believe the trial judge was empowered to and was obligated to rule on the legal defenses to conclude that, again, the plaintiff was not reasonably likely to prevail as to Marie, Mike, and Nada. And had she done that, she would have required the plaintiff to post a bond, and not having the benefit of a bond is the kind of irreparable injury that supports jurisdiction here.
And if I may, Mr. Berman,
Yes.
you alluded to the fact that this was before the court, but you have not provided us with a transcript of what was argued or what was presented to the trial court below. You agree with that?
Yes, totally. Our
Okay, and you,
Our
okay,
position is that everything was as a matter of law, so you don't need a transcript. The judge didn't need a transcript, and there was no resolution of credibility or contested facts. It was all on the judgments, the unimpeachable judgments against the plaintiff. But I agree, there was no transcript.
and I think that the difficulty here without having a transcript, and we're up here on cert, and you realize that's a very high burden that you have, especially on, for cert, that you're asking us to consider what was done below. And it's kind of difficult too, even though you say everything is there. Well, we don't know without a transcript, quite frankly. Somebody could have said something, somebody could have withdrawn something, and that puts your, I think your position a bit in a precarious one. Wouldn't you agree with that?
No, Your Honor, I believe just the opposite, that the judge, and you can see from the appendix what we filed in the lower court, separate detailed memos as to each petitioner, and we were required to a separate ruling as to each petitioner. For example, Madeline Silva, the complaint itself that's before the judge says that she was a co-conspirator before June 9th of 2011. That's doesn't require any testimony. There was no amendment to the complaint. The complaint, in fact, the complaint speaks for itself as to when Madeline was part of this conspiracy. So the transcript issue is a red herring. Again, as to res judicata, that's the centerpiece of our legal argument to the judge. And it wouldn't have taken her very long to say, well, I can't decide on res judicata because I need more facts. What facts would she need? We have the complaint. We have the Bondi and Dirks complaints. And if you compare those as a matter of law, you'll see that the theories and elements and transactions and communications are all the same. That my clients allegedly conspired to go to the police and make up things. And so again, there's really no need for a transcript. And again, the judge's ruling says, I cannot decide the issue on facts, but we didn't ask her to determine any facts. It was all as a matter of law. And then she said, this order is no comment on whether plaintiff is going to prevail. That's the exact thing she is supposed to do. She's supposed to assess the likelihood of prevailing in light of the arguments made by the moving parties to seek a bond. I would request, the court quash it and tell the judge what she needs to consider, including all legal defenses, not just facts, because the facts are undisputed from our standpoint about what is material. And there is a new summary judgment standard that requires a trial court to explicate the basis of ruling. So we think the appropriate course here is to quash, because this court seems a little reluctant to consider things such as res judicata, although I think it's manifest. This court is in the same position as the trial court to compare the complaints, look at the judgments, look at the voluntary dismissal with prejudice filed in 14-3884 on remand from Judge Moody's decision. I mean, everything is here. There's nothing for plaintiff to sue for as far as defamation, even if she was defamed to the hilt. The fact is, she could have alleged defamation either in the federal action, or she could have added federal claims to this action. And so the bar of res judicata applies. Doesn't matter the order in which the cases are filed according to Wade versus Clower. And so you have all the essential elements to make a ruling as a matter of law. And of course, the only impediment is the issue had to have been raised in the lower court, which it was by way of 20+ page briefs for each petitioner. So the lack of separate rulings is alone a basis to quash. The failure to address properly briefed issues is a basis to quash. And of course, a basis to quash is the trial judge didn't even consider. I mean, she just issued a summary denial, which this court has used to quash actions under Chapter 766. So there's tremendous grounds to quash this order and redirect the trial judge as to what she is supposed to do, which is determine, not on the facts, but is there a reasonable likelihood of prevailing in light of the law? I'll reserve the balance of my time.
Thank you, Mr. Berman. Mr. Husby?
I think you're muted, Mr. Husby.
Muted.
You unmute.
There you go.
Good morning, Your Honors. May it please the court. My name is Eric Husby, and I am counsel for respondent Christina Palin for this oral argument. And I would like to begin by addressing essentially what we're here to do is not to litigate the underlying case, but to determine if there has been a departure from the essential requirements of the law, which caused material injury, irreparable material injury to the aggrieved party, the allegedly aggrieved party, the petitioner in this case, petitioners, which are the defendants in the underlying trial court case. The order that they challenge, Your Honors, was entered, I believe, on March 22nd, 2022, as a result of a March 8th, 2022 hearing, which represented what the judge termed, the trial judge termed, a second half of an analysis under a specific statute, Florida Statute 68.093, designating plaintiff and a vexatious litigant and requesting a bond. First point to make, Your Honors, is that having been designated a vexatious litigant in the first hearing back in 2019 in the case did not represent a comment on any particular filings, the merits of any particular filings, or the purpose of any particular filings, or that a person was vexatious in the literal definition of that word. But it represents a finding that the plaintiff in this case, the respondent, had filed 5 or more actions. I believe there was a finding that it was 5 actions within a specified time period, which had been decided adversely to her. And in this case, respondent is filing several suits, a handful of suits in the matter to as has been phrased in her response to the petition, to clear her name as a result of a series of actions taken against her in the time period prior to the institution of this suit in 2012. So it was going into this hearing on March 8th, 2022. There was no determination that any particular suit lacked merit, or that she was engaging in any sort of vexatious behavior. A hearing was held in 2019, which found that the requisite number of cases applied, and then nothing was done to schedule the hearing on the second half of the motion, which was to request a bond. As the court had noted, there needed to be an evidentiary hearing or a full hearing on the issue of whether or not a bond should be entered. That was ultimately scheduled for the March 8th hearing, and there was a lengthy hearing that day. I believe it lasted approximately 4 hours, but it was several hours long. And in the order that was entered on March 22nd, the court describes what occurred, and essentially the court had taken evidence. The court had heard argument as well. It was not merely evidence, but it was evidence and argument. And the court will note that, your honors will note that under the statute, that's what is required. The court must hold a hearing and take whatever evidence and argument the court has to make a determination. And that determination under the statute is specifically whether or not the plaintiff in the case is reasonably likely to prevail on the merits of the action. And the statute also defines what an action is. It's not an individual claim in a case. There's no requirement under that statute that a particularized count by count, defendant by defendant analysis be made to determine if a bond should be entered on each or any particular cause of action or claim against a particular defendant. The court makes an overarching determination as to whether or not the plaintiff is reasonably likely to prevail on the merits of the action. And an action is defined as a civil action under the Florida Rules of Civil Procedure. And this case certainly does constitute an action, but each individual count does not have to be weighed where a bond would be issued on one count but not on another. And that appears to be part of the petitioner's argument, is that the court did not make a count by count or defendant by defendant analysis. But there's nothing in the statute that requires that to be done.
Well,
Now,
I will
yes, Your Honor.
observe, Mr. Husby, that
Yes.
the statute contemplates a determination that the vexatious litigant is not reasonable, I'm quoting here, is not reasonably likely to prevail on the merits of the action against the moving defendant.
Yes.
So,
And
so
all-
it seems to be,
correct.
you're right. I think you're right. The action is something more than a count by count, but it does say if, against the moving defendant, which seems to me to contemplate that specified determination as to that defendant.
Well, the action, of course, is defined in the statute, and that is Your Honor is correct as to the language of the statute, but it does. There is nothing in the statute in particular that requires that the order set out each count and determine and set forth what evidence or lack thereof applies to those particular.
Yeah, the statute doesn't seem to require that the order set out anything.
Correct, Your Honor, which is the next point I was going to get to, which is that the statute also indicates that any determination, well, the determination has to be based on the evidence and argument presented at this hearing. And it has to be a full and fair hearing, but it's not a trial. It's not a litigation of the merits of the action, because the very next sentence in the statute states that no determination can be used as a determination of the ultimate merits of the action. Essentially, it's an isolated determination to say, should there be a bond or not, but any ruling that the court makes, any finding that the court makes, cannot be later used to demonstrate either that the plaintiff's claims have merit or don't have merit, which is what the language in the statute requires, and what the court stated. When the court stated that nothing in the order would be construed as essentially, I'm not looking at the order, but essentially as a court's determination as to whether plaintiff will ultimately prevail. And that's what the statute requires. It's not an error as it's posited by the petitioners. It's not a bug, it's a feature. It is what the statute requires. We are having a streamlined evidentiary / legal argument for providing a full and fair opportunity to argue that a bond should be placed, but it's not a determination on the merits, nor is it a ruling on any of the issues, whether factual or legal. These are not issues that would later be able to be introduced as evidence that the court should say grant summary judgment, etc. So what we have, Your Honor, is a court which followed the statute to the letter. And here, the petitioners have not even identified what could be considered a departure from the essential requirements of the law, from the essential requirements of Florida statute 68.093. They disagree, defendants disagree that the court should have ruled on several issues in a different way. That's an appellate argument. It is an argument perhaps they could have moved or should have moved for reconsideration if they felt that way below on this pretrial order, but it is not a clear departure amounting to a miscarriage of justice, as the case law suggests, to show that the trial judge somehow did not follow the law. That the court's order parrots and states the requirements of the law as the court's order goes through what occurred, the chronology that occurred. The only the error that the plaintiff or that the defendant petitioner really points to is to suggest that there was not a sufficient explanation in the written court order that sets forth why the court ruled as it did. And unfortunately for the petitioner, it's not required. The court may well have stated on the record of that hearing the basis of its ruling, and the court heard the evidence, states that it heard the evidence, and indicates to some degree in the order what kind of evidence was taken to support the court's ruling, and then found that based on the evidence and argument, not just evidence, but evidence and argument is referred to in the order, the court could not find that plaintiff respondent was not reasonably likely to prevail on the merits. So looking at petitioner's own petition in this case, they cite one case for the proposition. It's a case interpreting a similar statute to the one we have today before us in Florida, but it's a California statute, Golan versus Allenby, 190 Cal. 4th 616. And I would point to the court that as far as persuasiveness or usefulness of that opinion in this case, it supports the respondent 100%. The ruling of the trial court in Golan was to impose a bond, and the court reversed that ruling, finding that the petitioner in that case, or that the defendant in that case, had not met its burden to show that the plaintiff was not reasonably likely to prevail in the action. That included on claims. I believe the Golan case also included claims for res judicata, legal arguments, not just factual arguments. And that case does say that the court must weigh the evidence, but it does not say the court must lay out in complete fashion in its order all of the weighing of the evidence. These are a lengthy hearings. These are hearings that the parties are allowed to introduce pretty much whatever they like. And the court makes a determination, did the defendant demonstrate and meet its burden to prove the negative, which is that the plaintiff is not reasonably likely to prevail on the merits of the action. And in that Golan case, the court found that the plaintiff had not done so. It did not rule that for the proposition that petitioners cited it for, which was that the court had to engage in this lengthy evaluative recitation during or in the actual court order. So if your honors would review that case, I believe it defeats the petition on its own, since that is the case that the petitioner relies on. Now, the petitioner also claims throughout that the court summarily denied their motion to require a plaintiff respondent to post a bond, but it was not summarily denied. Summarily denied would imply that it was based on the papers, and that, but here there's no dispute that there was a lengthy, full evidentiary hearing, and there's no dispute that there could have been a transcript here demonstrating what legal and factual arguments were presented, but that the defendants / petitioners opted, apparently intentionally, to not provide that to your honors to review. And that alone, under the case law cited in respondent's response, should also militate in favor of denial of the petition, because there is nothing for your honors to review. You don't know the trial court's analysis. Mr. Berman cannot present what they presented to the lower court. It's impossible to know whether the petitioner presented the same information to the trial court that is being presented to your honors in their petition and appendix, because that we could have known that, but we don't. The language of the statute is tracked by the court and complies with the letter of the statute. On page 4 of the petitioner's petition, also the key point is made by the petitioners that they're essentially claiming a denial of proper process through a procedural regimen. And that's case law cited on page 4 of their petition, but they haven't cited a failure of process here. What they're citing is disagreement, where they say they should have been held to have proven that plaintiff was not reasonably likely to prevail on the merits. And that's not a process or a procedural issue. That's not a clear failure to comply with the law. That's determining something different than what the petitioners would have you rule. And looking back at the procedure which is before the court, your honors will note that there was a motion for summary judgment filed and heard, and a ruling on May 2nd, 2019 concerning the second amended complaint filed by the plaintiff in that case. And in that motion for summary judgment, the issues of res judicata and collateral estoppel, among others, among all the issues in the case, were raised. And the court has a memo in the court record, the trial court has a memo, which it was presented in our appendix to your honors, which indicates that the motion was denied. So the court even held a hearing in 2019 on the issues which petitioner is raising and denied it. So that's another suggestion to your honors that there is no way to show that plaintiff is not reasonably likely to prevail on the merits of the action based on the arguments presented by petitioner, because the court already looked at that and said, no, we find that we're not going to find that. We're going to deny the motion for summary judgment, and the case continued. The case was then delayed for a period of time for a couple of reasons. I believe, the age of the case is of course a concern, but there was COVID intervening, and then there was one of the defendants who had filed a bankruptcy in 2018, which delayed the case for quite a while. And then that bankruptcy was dismissed, and the same defendant filed another bankruptcy, I believe in 2022, which again delayed the case because the case was ultimately stayed even as to the other non-debtor defendants for a period of time. So there was this time period in the interim, but there are reasons for that. Now, in terms of material and irreparable injury, the defendant's claim of material injury here falls flat, because the first thing that petitioners claim is that the case is being delayed by virtue of a bond not being posted. And that certainly is not the case. The posting or non-posting of a bond or the requirement of bond does not speed up or delay the case. That's plainly the fact. All that is required is that the plaintiff will post the bond. If the plaintiff posts the bond, the case proceeds as normal. If the plaintiff does not post the bond, then action is taken as a result of that not posting. But there is no delay, and there is no increase in cost, which is the next suggestion that the petitioner makes, is that we're materially injured because we're going to pay more money. And that's not the case because the case again proceeds as normal and they still have to file their motion for summary judgment if they choose. The case will still go to trial. The posting of the bond does not change that. Where there's some creative arguments on the part of the petitioner throughout their petition includes arguing that that they will not only that they've been delayed and will cost money, but that this statute somehow creates a sense of immunity on the part of the defendant. They raise the issue that it's a kind of immunity that they've been denied, which is absolutely not the case. It's not an immunity, it's a bond. And the bond for security would cover costs. And that is something that they would only be entitled to if they prevailed on the case and prevailed on a motion for costs and attorney fees associated with the case. There's no automatic right to attorney fees in this matter. There's a claim that a petitioner is going to be prevented from moving on to a judgment. They would have an unsecured judgment. There's no counterclaim in this case. There's no.
You
yes.
are at the end of your time.
All right, Your Honor, I apologize for that. That essentially closes the argument as we've covered both major points. Thank you, Your Honor.
Right. Thank you so much. Okay, Mr. Berman to rebut.
How many minutes do I have left?
I'll give you 6.
Thank you. The first argument is we don't know what was argued in the court below. Palin filed a brief, I believe through Mr. Husby, before the hearing before Judge Polo. We know exactly what she was arguing. I believe what she was arguing was, yes, I have judgments against me, but those actions were filed after this action. And that, of course, is not a valid argument under Wade versus Clower. We cited Golan for the proposition that showing that the plaintiff cannot prevail as a matter of law satisfies the requirement to post a bond. Now, in this case, the judge didn't make separate findings. Perhaps Judge Polo believed, as did Mr. Husby, that action means any particular claim in the action rather than prevailing against a particular moving defendant. So again, if Mr. Husby could make that mistake, perhaps the trial court did. And therefore, again, this should be quashed. As far as whether or not Ms. Palin is a, quote, vexatious litigant under the statute, Your Honors affirmed the vexatious litigant order issued by Judge Holder in the Gowdy case. So I think that establishes, as to Ms. Palin, that she is a vexatious litigant. She's not cross-appealing in this matter or anything. The other side continues to argue that unless there's a finding that this particular action is frivolous, the bond does not provide a basis on which to recover fees. We again addressed that. The Singh case in our reply shows that if a bond is posted and the plaintiff does not prevail, the defendants, moving defendants for whose benefit a bond was posted, are able to attach those fees. Now it's interesting. Let's suppose you find as to Madeline, it's time barred. She has to post a bond. She has to post a bond for the entire duration of the trial because she wanted a joint trial with 5 defendants or 4 defendants. So Madeline is going to be entitled to her full fees for the entire trial. And yes, during that time, we will be defending as to any other defendant. But by naming all of these people as defendants, this is the predicament she brought on herself. Mr. Husby does not address res judicata. in his argument, and that's because he's certainly aware of the Tidwell versus Witherspoon case where the plaintiff first sued for malicious prosecution, lost, then tried to bring a defamation claim, and the court said that was precluded. As far as this May 2nd, 2019 court memo, a court memo is not an order of a court. It doesn't say if anything was denied with prejudice. It could have been denied procedurally because Khalil had not been deposed at that time, and Judge Rice was trying to set a trial date, and we were trying to set motions, dispositive motions, and Judge Rice said, well, I'm not going to grant it right now because Khalil has not been deposed. And of course, he was not deposed thereafter, either because he filed bankruptcy or because Ms. Palin was waiting for the second leg of the vexatious litigant hearing. We actually moved in 2016 to declare her a vexatious litigant, and the order declaring her a vexatious litigant was made in 2019 by Judge Rice, and then it was readopted by Judge Polo in 2022. So this court memo, it means nothing in this case. It doesn't, and it was only as to Khalil Abdo anyway. There's no denial as to any other defendant that I represent. So I believe strongly that the better course of action for judicial economy is to quash this order. And the court has the power as a de novo court to say that plaintiff is not reasonably likely to prevail based on the statute of limitations and res judicata. And yes, that would have the effect of telling the plaintiff that if you post a bond, you might lose your bond because the Court of Appeals thinks that your case is precluded by affirmative defenses. And I'm aware of that. The broader issue is, should you grant certiorari in a case like this? And I think to do so, you have to find the defenses are proven conclusively as a matter of law. Because obviously, if Judge Polo said, oh, the plaintiff alleges that Khalil, made a secondary defamatory statement, your honors can't weigh that. But what you can do is determine if there's a preclusion defense or a statute of limitations defense. So
Mr. Berman, your time is up.
thank you very much, your honors.
You both, in order to go leave our courtroom, you click the button on your Zoom screen called leave, and you'll be gone.
Thank you.
Thank you both.
Thank you, Your Honors.
All right, the court will be in recess for 10 minutes.